Hi everybody, you're watching the Virtual Amicus and I'm Jay Lodha. Well, the Virtual Amicus, where the focus is always on good research over glamorous presentations and quality content over clutter. So today's topic is quite special as our speaker today, the Insolvency and Bankruptcy Code. So a lot of people tend to mix these three terms, the insolvency, bankruptcy, and liquidation, where insolvency is more or less like a state or a financial position wherein a person's liability is obviously exceeding his assets. And there is one more thing that I wish to say, that prior to the commencement of the Insolvency Bankruptcy Code, or prior to the enactment of the code, the legislative framework in India, kind of dealt with insolvency and restructuring procedures pertaining to corporate entities, partnership firms, etc., etc. These processes were very complex. They were fragmented across multiple legislations. There were a number of legislations that were involved, like the Companies Act, the Sick Industries Companies Special Provisions Act, Surrogacy Act, etc., etc. So this became more or less like a collective mechanism for resolution of insolvency in the country. And this was a wonderful balance that came into being and came into the picture. And so today we have with us a very special speaker who's joining us from Delhi. He has a stellar record. So I'm tempted to share it in detail, but I had to cut short owing to the paucity of time. We have with us Mr. Manan Shishodia. He is a disputes lawyer practicing primarily in the area of civil and commercial law. He's currently an associate at the chambers of Mr. Abhijit Sinha, where the primary focus is on commercial arbitrations and insolvency litigation. He's also an associate research fellow at Vidhi Center for Legal Policy, Corporate Law and Financial Regulation team. So prior to this, Manan was an associate at the chambers of Mr. Samar Bansal for the period of 2 years, where he worked extensively on civil and antitrust cases and has a number of report judgments to his name. And he has argued and assisted in cases before the Honorable Supreme Court of India, Honorable Delhi High Court, arbitral tribunals, and National Company Law Appellate Tribunal in New Delhi. Prior to working there in the aforementioned litigation chambers, he was a judicial law clerk cum research assistant to Honorable Justice Rohinton Fali Nariman, Judge Honorable Supreme Court of India from 2017 to 18. He holds a bachelor's degree in arts and law, BA LLB honors, with a first class honors from Jindal Global Law School in India. And he is an incoming LLM candidate at the prestigious University of Pennsylvania, Carey Law School class of 2022. Wow, that is some introduction. Thank you so much, Mr. Shishodia, for sparing and taking out time from your busy schedule. The stage is set, the
Thank
floor
you
is
so much, Jay.
yours. Over to you.
Thank you so much, Jay, for the kind introduction. So now, starting with my presentation. So a very good evening to all of you. So today's topic, as you know, is the basics of the insolvency and the bankruptcy code. So now, firstly, it is important for us to understand all these terms. So firstly, what is insolvency? Now, insolvency is a state of a person, firm, or a corporate person who does not have sufficient funds to pay its own debts. Now, just to give you all an example, a company XYZ borrows rupees 100 crores from PQR Bank. After a certain period of time, if the company XYZ is unable to repay the loan, then XYZ is said to be insolvent. Now, understanding what is the meaning of bankruptcy. Bankruptcy is when there is a determination of insolvency by a court of law that enables the creditors to exercise specific rights against an insolvent individual, firm, or an organization. Now, just to give you an example, in the above example, if the court, after analyzing all the loan papers, makes a finding that XYZ is insolvent as it is not in a position to pay rupees 100 crores, then XYZ can be said to be bankrupt. So now it is important for us to understand the difference between insolvency and bankruptcy. So the difference between bankruptcy and insolvency is that bankruptcy is essentially the legal recognition of the insolvent situation of the individual or the company. When an individual is declared bankrupt, then their assets have to be sold or a restructuring process has to be implemented to pay off the debts. So it is very important to know that every bankrupt person or company is insolvent, but every insolvent person or company may not be bankrupt. So just to give you an example from the previous slide, if XYZ is not able to pay 100 crores, it is said to be insolvent. But if the court finds that they are not insolvent and they can pay, then they are not bankrupt. So therefore, it will fall in the latter category of insolvent person but not bankrupt. Now, it is also important for us to go into the legislative history of this code. So prior to this code, so as you all know, this code was enacted in 2016. So prior to the enactment of the code, the insolvency and bankruptcy was incorporated in different statutes, which are as follows. The Sick Industrial Companies Act, Recovery of Debts due to Bank and Financial Institutions Act, Securitization and Reconstruction Financial Assets, Enforcement of Security Interest Act, Companies Act. These were the four legislations. Now, what is the purpose of the Insolvency and Bankruptcy Code? So, first and foremost, to bring all the existing laws under a single unified umbrella. So, all the four acts that you see listed right above you, the purpose of the IBC was to bring it under a single unified umbrella so that there is one code through which the resolution of companies can take place. Then, second is faster insolvency resolution in a time bound manner. Now, the World Bank report of 2016 basically said that the average insolvency in India takes around 4.3 years, which is roughly 4 to 5 years, as long as a prime minister's tenure, as compared to a year in UK and 1.5 years in US, where the jurisprudence and the law is much more developed. So the purpose of this code is to basically curb this gap of 4.3 years to a considerably lesser time. And now I'll come to the timelines on the next slide. But the main purpose was also to reduce this gap time of 4.3 years to substantially lesser. Then ease of doing business. And second, effective mechanism for creditors. Now we'll also come to what the adjudicating authority under the Insolvency and Bankruptcy Code is. Purpose why the Insolvency and the Bankruptcy Code was enacted has been elucidated beautifully. Now, it is important for us to understand who can initiate an insolvency process. And for that, we'll have to understand what these terms are. So, an insolvency process can be initiated by a financial creditor under Section 7 of the Code, or by an operational creditor under Section 9 of the Code, or the company itself, Section 6. So, now what is a financial creditor? Financial creditor, firstly, is defined in Section 5(7) of the Code. So 5 subclause 7 of the code. So financial creditor could be any person to whom a business debt is owed, or a person to whom such amount is legally assigned or transmitted, for example, a bank or a financial institution. Secondly, it can also be initiated by an operational creditor. Now, what is an operational creditor? That is defined under Section 5 subclause 21 of the code. So operational creditor could be any person to whom an operational debt is owed, and includes any person to whom such amount has been legally assigned or transferred for goods or services done by them. So the goods or services is the essential aspect here. For example, vendors and suppliers, employees, governments. All of them fall in the ambit of operational creditor. Now, once an application for insolvency has been initiated, the basic question is who gets to decide, which is the adjudicating authority or the court. So the court has streamlined the insolvency resolution process with the creation of specialized national company law tribunals, which are obviously in common parlance called the NCLTs, which adjudicate on the insolvency resolution for corporate entities. The resolution process is conducted by licensed insolvency uh, resolution professionals who are called the IRP. So first an IRP is appointed by the NCLT, and once his appointment is confirmed, by the committee of creditors, he becomes the resolution professional. So the code has established a specialized insolvency and bankruptcy board of India, which in common parlance is called the IBBI, which is responsible for the regulation of various aspects of insolvency and bankruptcy, including issuing and forming regulations and regulations of insolvency professionals. And in general, the IBBI website is a great resource for you to learn all the latest developments in law in the area of insolvency and all the latest regulations and all the new enactments by the parliament. So the ibbi.gov.in is the website. Now, coming to the question as to how time bound the process is. So, we learned that the World Bank report says that the average insolvency process in India takes 4.3 years. Now, why was this code enacted and what timelines does the legislature want us to follow? That is important for us to know. So, the IBC code has framed a time bound process for insolvency resolution. Under the code, every insolvency resolution process is to be concluded within 180 days of the commencement of the process, which is extendable to a further period of 90 days. And this is stipulated under Section 12 of the code. However, there has been a very important amendment on 16th August 2019, which basically says that the insolvency resolution process is now to be completed within 330 days of the commencement of the process. So now there are two landmark cases which emphasize on this fact that the CIRP, the corporate insolvency resolution process, has to be completed within a period of 330 days. The two important judgments are SR Steel versus Satish Kumar Gupta. The citation and para number is on the slide. And Manish Kumar versus Union of India and another. Paras and the citation is here. And just for your reference, this slide will be shared with Mr. Jay Loda so that he can share it with all of you. And in case you have any doubts at any point of time, I'll also be sharing my email address and you may feel free to reach out anytime. Now, we have learned that it's a time bound process, but what is important to know is what happens during this process. So during this process, a moratorium is imposed on the company. Now, what is a moratorium? Moratorium is basically a period when the CIRP is initiated against the corporate debtor. During this period, no judicial proceeding for recovery, enforcement of security interest, sale or transfer of assets, or termination of essential contracts can be instituted or continued against the corporate debtor. So, in a way, all the legal proceedings that are pending against the corporate debtor are stand dismissed from the moment it goes into CIRP, except criminal proceedings. And regarding the exemption for criminal proceedings, I would urge all of you to have a look at section 32A of the code. So what happens during this moratorium is that this serves as a crucial purpose of preserving the corporate debtor's assets and facilitates the orderly completion of the resolution process. Because if the assets are in the possession of the IRP, then a resolution plan can be formulated where all the creditors get their dues. Which is why it does not make sense to have any parallel proceedings and impose a moratorium on the company so that the assets are secured and a resolution can be carried out. Now, as you know, the resolution is finalized through a resolution plan. So what happens subsequent to a resolution plan? Now, firstly, resolution plan has to be approved by the committee of creditors, and a spate of judgments have said that the commercial wisdom of the COC is of paramount importance. So, court has very less interference in the resolution plan. But where does the court really step in after resolution plan has been finalized? So now the role of the court is basically emphasized in section 31 of the code, which deals with the approval of the resolution plan, which says that once the resolution plan has been approved, it would be binding on the central government, state governments, and any authority to whom the amounts are owed. The intent of the amendment, as noted by the finance minister, was to ensure that the governments and statutory bodies respect the IBC process and do not proceed against the entity which acquired the status of a corporate debtor for past dues. Now, coming to the very important aspect as to how has COVID really impacted the insolvency and the bankruptcy code. Now, with the onset of COVID-19, the monetary threshold for initiation of insolvency and liquidation process of corporate debtors has been raised to 1 crore from a previous amount of 1 lakh rupees. So this has been done by the notification dated 24th March 2020 under section 4 of the code. And then the IBC has inserted section 10A has been inserted in the code with effect from 23rd March 2020, suspending initiation of insolvency proceedings for any default arising on or after 25th of March for a period of 6 months. So this period of suspension has been extended by another 3 months until December 2020. So now the NCLAT, by an order dated 30th March 2020, directed that the period of lockdown shall be excluded from the period of completion of the CIRP. So what we had initially learned is that 330 is the strict timeline, 330 days is the strict timeline that has to be followed. But NCLAT, by the order March 2020, had said that this period of lockdown shall be excluded. And lastly, a provision has been made for exclusion of the period of the lockdown from the computation of timelines for proceeding under the IBC by insertion of Regulation 47A in the IBBI Regulations 2020, which amends the IBBI Liquidation Process Regulations 2016. So these were the important aspects which I thought give a basic overview of the IBC. And there are a spate of landmark judgments which have been passed by the Supreme Court and the National Company Law Appellate Tribunal, be it the Swiss Ribbons, be it the SR Steel, be it Innoventive, be it Mobilox. And if anyone is interested for a deeper understanding or a deeper discussion on those judgments, please feel free to reach out to me through mail or on phone. Thank you so much.
Well, thank you so much, Mr. Shishodia, for this brilliant presentation, with respect to an overview that it gave all the viewers on IBC. And to all the viewers, feel free to write to us in case if you have any query. We would be more than happy to forward the same to Mr. Shishodia on this very subject. And in case if you want a copy of the presentation, you can write to Mr. Shishodia directly, or in any which case you can write to me and I can forward it to Mr. Shishodia for a copy of the presentation. So thank you so much once again for this lovely presentation, and
thank you so much, Jay, for the invitation.
Thank you so much. Thank you. And a big thank you to everybody for this patient hearing. And stay tuned. Next episode is on its way. Please like, subscribe, and share my channel. Please stay home. Please stay safe. And please take good care of yourselves. And thank you, Mr. Shishodia, once again. And see you all super soon in the very next episode. So take care and goodbye for now. Thank you. Thank you so much.
Thank you so much.